viewers, you're very welcome from my live show from a different platform, social media. Today, I'll speak about what you should do, what step you should take when your relationship break down with your spouse, whether you are in spouse visa or whether you have leave to remain on the basis of human rights, such as including on the basis of a relationship with a British child or settled child, or on the relationship of with your spouse or British partner. Now, you might have to leave to remain on the basis of a spouse, which is 5-year route FLRM, or you might have leave to remain on the basis of your relationship with a British or settled child in the UK, or you might have a visa on the basis of a relationship with a partner, FP 10 years route visa. Whatever it is, you sometimes the non-EU spouse is very vulnerable, means your visa, your future is depend on your spouse or on your relationship, because when you will apply for extension, you must satisfy that you have subsisting and a genuine and subsisting relationship. If you fail to satisfy the requirement of genuine and subsisting relationship, your visa will be refused. We see from our experience many spouse dependent fail very serious views from the other spouse who is settled in the UK. Some cases. Now, for whatever reason, if your relationship is breakdown, if you separated from your spouse, then your position is, by operation of law, your visa will be revoked. It doesn't matter whether Home Office will write a formal letter or not, as soon as, because she is your sponsor. So if you are not with her, if your relationship background, you move to a separate property, you are separated from her, irrespective of whether you still have any kinds of connection. But if you are not a relationship, your visa is removed, visa is terminated by operation of law. Maybe in future your spouse will report to the Home Office, or someone else will report to the Home Office, and Home Office will write a letter. Or when you will extend your visa, Home Office will find there is no evidence of your relationship, or from their HMRC record, they will find that both of you are living in two different addresses. Accordingly, Home Office will refuse your visa. Today, I'll discuss because when you have a child with the spouse, then what step you should take immediately. Remember, if you have a child with the other spouse, or if you get leave to remain on the basis of your relation with the child, if you are not live with the child, if you are not a carer, if you are not involved of the life of the child, again, you will not get leave to remain in the UK. So, if your relationship break up, if you separated from your spouse, if you separated from the child, then you must do some step. You must take some important step to continue your leave to remain. That is something is involved in family law. So some point, immigration and family law is connected, and that is one of the point. When you have right on family, when you will get a remedy from the family court, that will give a legal basis of leave to remain in the immigration. I'll explain you how. And that is what the step you should take. For example, you are on spouse visa in the UK. You have a British child or a child settled in the UK. Or you have a leave to remain on the basis of your British child, because you, your wife, your child living together. In some point of your life, you have an issue come with your wife or your husband, and then you separated. Maybe she reported to the police, or voluntarily you was unhappy, disappointed, and you left family home and start living somewhere else. What is your immigration status at this point? I said by operation of law, you will have no leave to remain. Your visa automatically will be removed. So what step you should take to continue your leave to remain. First issue, if you have a child, you must have access to the child. So you need to make an application immediately to the family court to see your child. Now, this is a very technical point. Some of the spouse are familiar with this because they do research, they do study by themselves, and they know that if you get a court order, then more likely you will get leave to remain on the basis of your connection, on the basis of your access right from the with the child. You will get your visa. So what they do, sometimes the clever spouse, they come form of concession, said, well, look, we are separated, but child is ours, so let's involve both of us, we'll look after the child. So she or he will give you, take the child, you look after in a formal way. Now, that will not give a legal basis. What the Home Office always want a court order. So a child arrangement order, contact order, Section 8 order. And then when you give that order to the Home Office, then they believe, yes, you have a relationship with your child, you are involved on child life. So what the always Home Office want, I made many applications, separated dad, or separated mom. They always want a relationship with the child which is recognized by the court. So when you are separated from your spouse and you have a child, you must immediately make an application to the family code, which is child arrangement application, to see your child. Even though if you voluntarily both party agree to see the child, but still you can make an order to the family court by using C100 form, a child arrangement order by consent. Okay, so that will be more easier. Even though, for example, your wife offer you to see the child, take from his school, or every weekend you can take the child for overnight, but still you should go to the court, you should go to the family court, and the family court make an order by consent, and then court order will be your legal basis. That is your proof that you have a legal right, you have a right to access to your child, which is recognized by a court order. All right. So this is what I said. This is the one of the most important way you can continue to leave to remain. Now, you don't need to be make an application immediately if you are on the if you are on a leave to remain on the basis of your relationship with the child. However, if you are on spouse visa, for example, you came in the UK spouse visa, or you applied it by using the form FLRM, and you got leave to remain on the basis of your relationship with your partner, then if you're separated and you got a contact order on the basis of your child, you should make an application to bury your leave to remain. So what will happen if you just stay on the spouse visa, you are separated, but you got a child contact order, but you didn't make an application to bury your leave to remain, then what will happen? For example, after 6 months, you make an application to extend your visa on the basis of your child. But 6 months before, by operation of law, your visa already terminated because you wasn't with your spouse. So what you should do, once you get the court order, immediately you should make an application. Don't wait that I have still visa for 1 year. It doesn't matter. You should make an application as soon as possible to switch visa from partner visa or spouse visa to FLRFP visa on the basis of your child. So that will give you a leave to remain on the basis of child. As soon as you maintain your relationship with the child, as soon as you maintain your relationship, you exercise your access right, you pay that maintenance to the child maintenance, you contact with the college, the school, you have recorded in the GP as a father or as a guardian, you can apply and you can continue to leave to remain. This is the one of the important aspect, because from our experience we saw many people separated and they had visa for 1 year left. They think, well, no worry, I have a visa, I will continue to live, and they come after 1 month and say, look, I need to extend my visa. Unfortunately, we cannot help that time, and more likely Home Office will refuse at that point. So it is better to take right step in advance, then you'll find a way to live in the UK. So this is about the relationship with the child. Now, as I said, it's a family law involved. You must make an application to the family code using the form C100. You can make this application online. This is a child arrangement order. There is a fee 240 or 55 pound. However, if you are on benefit, if you are on low income, you can apply for an exemption. And most of the case, I regularly appeared in the family code. Most of the case, the court order the father, to court order always to the mother or father to give access to the other parents, unless there is a serious allegation of domestic violence. Even though if it is any allegation serious allegation of domestic violence, still the court list the hearing for fact-finding hearing, and then after the fact-finding hearing, the court will consider the welfare hearing, and after that, court make a decision. Unless it's exceptional case, most of the case court consider that the both parents' involvement of the child life is the best interest of the child. Accordingly, court give access to the father, either direct access or indirect access, or via the contact center. Now, some cases where thus you come on spouse visa, however you don't have any child, so you are very vulnerable position. Is there any law which give you protection? Because other parents, what I talk about, that they have a child on the basis of the British child, on the basis of the court order, on the basis of the relationship with the child settled in the UK, they got leave to remain under FLRP. How about those parents who doesn't have any spouse? How they can live, because they cannot make any application to the court to get access to the child. Is there any chance to give protection? Yes. Now, there is a lot of way you can find options. For example, if you come on the spouse visa, and if your relationship break down because of domestic violence, then you can that is a long process. However, you can claim indefinite leave to remain on the basis of a victim of domestic violence. Now, it is very important, I will say, and many people do this mistake. Back in, I think, last 3-4 weeks before, one lady called me from Pakistan, and she said to me that I was in spouse visa. My sister was in spouse visa, and she came to UK, and some point their relationship arise between her partner, and what the partner, they have 2 children. What the partner did, he took the wife and the child in holiday in Pakistan, go over there, take the passport of the children and wife's passport, and then he left them here in Pakistan and came to the UK. Their visa expired, and now they're stuck over there. They cannot come. And this gentleman refused to bring them back. So you have to be very careful about the motive of other spouse. If you think your relationship will not work, either you can go mutually. But however, if your relationship break because of the domestic violence, most of the relationship, especially from Asian background, most of the relationship break down because of domestic violence. And no one want to break down their relationship. It's not only Asian. I work with many Arab community. I have lots of Arab clients, and everywhere I found, even in UK, no one want break their family. They love each other. They are understanding. But in some point when everything go beyond the control, and the couple cannot live together, and the other couple who are non-new, who dependent, they find them very vulnerable, and that some point they think might be, if I not obey him or her, then he will send me back. I'll have no visa. So he or she accept all kinds of abuse, financial abuse, physical abuse, verbal abuse, mental, psychological abuse. But this is, I think this is something wrong, because if your relationship doesn't work, you should consider what you can do, because it might be the impact is very long-term, lifelong impact on your mind. You might be suffer a very severe depression, and dementia in future will come. So rather than go that stage, you should take step. You are not a vulnerable, as I said. The law will give you protection. If you become a victim, if you are on spouse visa, and if you become victim of domestic violence, what form of domestic violence? Now, you first, what you need to do, when you see you are a victim, you should take step. And if you can establish you are a victim, if you're a victim of domestic violence, and if you satisfy the other eligibility requirement, you can make an application to the Home Office, and then you will get indefinite leave to remain. This is only when I say you are a genuinely become victim of domestic violence. Now, what is domestic violence? I'll come to this point later, because there are a misunderstanding, especially from Asian background, that we consider sometimes that the domestic violence only when someone beat each other. This is not. The current definition of domestic violence, which is introduced by Domestic Abuse Act 2021, very wide. So, for example, I'll say economic abuse. So economic abuse is also a domestic violence. What is economic abuse? Economic abuse is when, because of the partner or someone's behavior, the other person limit his ability to buy goods, ability to spend money. So that was the economic abuse of domestic violence under the current domestic violence, which is passed by this year. So, for example, you are on a spouse visa, you look after home, and other spouse work, so he bring the money, and he gave you £100 every month, okay, or he doesn't give any money, he control the benefit, you came on a spouse visa, just look after home, you don't have any right, you don't have right to go outside to buy something, because you don't have money, because your other spouse control money, you have to rely on him. In some form, in some extent, this is also domestic violence, because the other partner behavior limit your ability to buy something, limit your ability to spend money, to buy goods. So that's what the definition is here now. Now we discourage, but still, if you find yourself you are a victim, what you should do. Now, first things, when you say no, I have no room left to take all this abuse, you should report to the police. First, save yourself, okay? Put yourself safe position. So you can go to next door, or you can leave the homes, put yourself in safe position, call to the police. Go to the police, and then you can ask the police to hand over to lots of charity work with women, or there's some charity for men, ask for help, okay? You will get legal aid, so you don't worry about the legal fee. You can make an application for non-molestation order to the family court. Generally, or emergency situation, we applied and without notice to other parties, so within 2-3 hours even, or a day, we get a non-molestation order. You can also make an occupational order, which is the family home. So court will order other spouse to leave the home and left the home for you only, okay? So some situation, so you can get a non-molestation order without notice, and then you will get you can also get a occupational order from the family court. Once you get a non-molestation order, emergency notice, or with notice or without notice, then what the next step is, immediately we make an application, DBC. DBC mean domestic violence concession application. So within 1 week, 2 weeks, you will get a leave to remain, temporary leave to remain for 3 months with access to public fund. Okay, because your current leave to remain is current visa doesn't allow public funds. So first concern for me, what I do, I make an application to the Home Office, to Liverpool, which is DBC, domestic violence concession application, because this application is one-stop service. There is a duty caseworker in the Liverpool, and he immediately within a week issue the BRP card, will write a letter, and then you will get access to public fund. So first step, we make a application to the Home Office to immediately, they will temporarily give 3 month time with access to public fund, and then immediately after you get this visa, within a week you will apply for benefit, How you'll apply for universal credit, you apply for accommodation, you apply for all sort of, if you have a child, you'll apply for child benefit, everything, whatever public fund available, you'll make this application. So this is the first step, okay? And then you will get 3 month time. So by this 3 month, I will make an application, or your lawyer will make an application for indefinite leave to remain as a victim of domestic violence. Okay, then by the time after maybe 4 months, 6 months later, you will get your indefinite leave to remain as a victim of domestic violence. When you apply for victim of domestic violence, you will apply for ILR. You don't need to satisfy any requirement, that is life in the UK test or English language test. You don't need. You just need to be established that you were a victim of domestic violence and you got a court order. Okay, then you can, on the basis, whoever your lawyer, they will make this application. Now both application, generally it covered by the legal aid. So I know, but finance is an issue because you had no money, you had no right to claim benefit. So probably if you got a good lawyer, someone will help and guide you throughout the whole process, and then you'll get ILR. Now, so that's why I said that there is two issues. Today my discussion is both family court. Now, in terms of domestic violence application, you need to make an application, FLR Georgia 4, which is under the Family Law Act 1996, which is a non-molestation order under rule under section 62, 33 and 42. So you'll make an application, get an order. First you'll get an order without notice, emergency, and then after maybe 2 weeks or 3 weeks later, there will be a return date. So your ex or your spouse will come as well, and you will go to the court. If you go to the family court, there is a separate room. Generally in the family court, the judge chamber, there is a middle, there is a wall. So spouse will sit one side, other spouse will sit another side with his lawyer. So there is no chance to meet each other. And also the consultation room are separate normally in family court, so both will be separate. If your spouse doesn't want to defend your application, court will make a order, final order. If your spouse doesn't return to the court, again this will be the final order. Most of the case, when genuinely someone views someone that don't come return to the court, and accordingly the court make the order as a final. If your spouse return to the court with his lawyer, because he will not get legal aid. So perpetrator means those who abuse other, they will not get legal aid, so they need to pay privately. Most of the case, they don't want to waste their money, and they decided to give up. And then what they do, they don't appear to the court. If they come in case, then it will be a short adjournment, means the court will issue further direction, and then the court will fix another day for the final contested hearing, and that day could be the final. Court also sometimes give direction for disclosure from the police, from local authority, or from any other authority who involved in the family previously. So they disclose their their record as well, GP record. So sometimes the court give direction, disclosure, and then the court will be listed for the final hearing. In the final hearing, court will make a decision. In the domestic violence, sometimes the other party give the undertaking. Again, if the undertaking which has similar effect, but if the undertaking, if breach of undertaking is not an offense, by will not arrest police. But if breach of a non-molestation order is a criminal offense and could be face prison up to 5 years. So this is how when you are on a spouse visa, and when you become a victim of domestic violence, and if your relationship break down, then immediately you can make an application for non-molestation order, and then on the basis of this non-molestation order, you can apply for indefinite leave to remain. If your relationship break down for any other reason, and if you have a child, once your relationship break down, you should immediately make an application to the family court for child arrangement. And once you get a child arrangement order, then you can make an application to bury your leave to remain. So you will switch your visa from spouse visa to child dependent FLRFP visa, and then you can continue. And again, as soon as you can maintain relationship, but if you give up just after get a court order and you give up, you don't see your child, you don't pay child maintenance, you don't go to school, you don't attend parental meeting, you don't care about the child, again this will not help you. So what will happen, maybe court will the home office will ask more information. So do you pay child maintenance? You can provide the evidence that you pay child maintenance. Maybe they will ask you to, okay, give a letter from the school that you have a contact, or you attend parental meeting, you are the child father. So all these things, sometime will be subject to again further information home office could request. Now, when someone can claim, again I will tell again, family law, child arrangement order, who can make an application. Now it is important, if you want to make an application to the family court, you must have parental responsibility. You must be, so who have a parental responsibility, who, if you are married, on that basis you can have the parental responsibility. If your name on the child birth certificate, on that basis you can have a parental responsibility. So all these things is very important. So when if you have if any child born, make sure your name correctly register on the child birth certificate. This is all about today. So today I discussed about what you should do when your relationship break down with your spouse, if you're on a spouse visa, or if you have leave to remain on the basis of your relationship with a child, whether it's a British or settled in the UK, and if your relationship break down with the other party, other spouse, or the child mother or child father, what you should do. This is all about family law, mixture of immigration law. I'm happy to help you if you need it. I do practice immigration and family, so if anyone need any help, please feel free to contact me. And next, I will take some question. I think many question on the screen. Right, this is my number. So if you need any help, please feel free to contact me. Let me take the question. Many people may come on, but I cannot take. Sage Shakal, Assalamu alaikum. Always good support. Love you. The video and emerging information. Very helpful. Keep it up. Thank you, Saki Bhai. I hope you are good. Next question. Hello, sir. Please, sir, what about couple lived together for 1 year before change address? I mean, live in different address. Well, if you live in different address, that means you don't have a relationship. If you have a genuine relationship, your address should be the same home. When home office will ask to give them evidence of relationship, they need to provide them all bills that you are living together. Jamal Ansari, my regular viewers. Hello, brother. I am from Afghanistan. I had my interview 14 months ago. Still waiting for decision. I don't know what to do. My friends had interview after me. Everyone got refused visa for 5 years. Everyone got refused visa for 5 years. I don't know what to do. Brother, I do understand you don't have your substantial interview, but you shouldn't chase up them. You should wait. Maybe you can write a letter, ask them what is the situation, but it's not wise to chase them up. And also, I do believe you have right to work. If you don't have, you can make an application for work permit. And secondly, you can request the Home Office to give you right to work. Secondly, also it is important that you might get all the support benefit, so enough support. So if you are not, you can claim support from the Home Office. Other than I will tell you. Also, you can contact with your MP, request them what is the situation. 14 months is quite long. There's something wrong, because normally a lot of people are getting decision within getting a substantial interview within 7 to 8 months. I think maybe there is an issue, so you can look into it. Afghanistan, my brother who are from Afghanistan, currently a lot of decision made on Afghanistan in asylum visa. I made quite many further submission as well, because the current situation in Afghanistan has changed. So if your application for leave to remain, your application for refugee been refused previously, and you don't have any application pending, now you can make a further submission to the Home Office. I made many further submission, and alhamdulillah, 3 months before, I made once further submission, and around 2-3 weeks before, the Home Office gave the decision, and which is positive. My client accepted refugee visa. His application was pending and refused 11th year before, and now that circumstance in Afghanistan has changed. Taliban take over, and there is an issue of breach of human rights, and more likely many Afghan nationals in the UK, those who got asylum, some of them application was refused for many reasons. So I don't know exactly what is whose situation is, but if you are an Afghan nationals, now currently you can make an application to the Home Office, or you can make a further submission to the Home Office, explaining what is the current changes, what is the current situation, and obviously you have to write details. So Jamal Ansari, you can share this information with your Afghan community. Now a lot of positive decision is coming from the Home Office regarding asylum claim of Afghan nationals. Those application which was refused by the Home Office, now you can make a further submission, and more likely your application for a refugee will be granted. Thank you. Muhammad Shah. Hello, sir. Can you please tell me how long does it to get work permission from Home Office as a asylum case? I was studying for a year. How long does it for time when I submit work permission application? Yeah, thank you, Muhammad Shah. Generally, first you can make, if your application is pending, then you can make a request. Generally 2-3 months there give a decision of a work permit, and most of the case the application are requested or accepted. Very rare in my hands that an application for request for work permit is refused. So 2 to 3 months it take. If not, then you should chase them up. You can contact with your MP, ask them to write a letter. Thank you very much. Stephen Alexander, I still haven't received my certificate of application. I am not sure what do you mean by certificate of application. Might be you can make an application under Zambrano right or anything. If you make clear, I will give your answer. Thank you very much, all of you who watch my video. I will be live next time as well. Today I spoke about spouse, if you are on spouse visa or leave to remain, and if your relationship breakdown because of any reason or domestic violence, what step you should take to regularize your immigration status in the UK. Thank you, all of you. Take care. Inshallah, I'll see you next time when I'll come live. Bye for today.